Hi, hello. Today we will discuss about Torts development by courts in England. So this topic will come under evolution of law of torts. Before going to discuss about torts development by courts in England, we should know about what is a plaintiff, what is defendant, what is tort, what is crime, what is breach of contract. Let us see what is tort. Tort is a civil wrong. Means it's a it is applicable to human being. So it's a human mistake. We can say civil means a human. It's a human mistake. So what is tort? Means a tort is a civil wrong that results in harm or injury to another person and for which the injured party can seek compensation. Torts are not necessarily criminal offenses, but they can be. So, examples of torts include negligence, defamation, and intentional torts such as assault. So, this is about tort. Once again, I am telling tort means it's a civil wrong, nothing but it's a human mistake. Next, we shall know about what is crime. Crime means everybody knows it's a regular terminology we used to hear. So, a crime is a violation of criminal law that is punishable by the government. Government in the sense courts. So, crimes are considered as to be offenses against society as a whole rather than just the victim. Examples like murder, theft, drug offenses. This is about the crime. Next, what is a breach of contract? A breach of contract occurs when one party fails to fulfill their obligations under a contract. Breach of contract is a civil matter, and the injured party can seek damages to compensate for any losses they suffered as a result of the breach. This is about the breach of contract. So, contract between A and B. So, if A violated or breached the contract, then A should be payment to the B. So, that that really matters severity of the contract. So, this is about a breach of contract. Now we understood that what is breach of contract, what is crime, and what is tort. Along with this, we also should know about plaintiff and defendant. So, in our torts topic, regularly we used to hear plaintiff and defendant. So, what is plaintiff? A person who brings a case against another in a court of law, that is a plaintiff. So that in the sense, suppose if you are taking A is one person, B is another person. So A showed a case against B. So that in the sense, A will be called as a plaintiff and B will be called as a defendant. So B can be an individual, company, or institution. So that is what defendant saying that an individual, a company or institution should or accused in a court of law. That is defendant. So before going inside law of torts, one should know about plaintiff, defendant, what is tort, what is crime, what is breach of contract. So let us move on to the first topic from evolution of law of torts, that is torts development by courts in England. So how are we going to learn about this means? We should know about history of Torts development, how it happened in England, and what were the developments has been done so far. That also comes under England. So we should know about history and what kind of developments so far done in England court. So let us discuss about one by one. So the development of tort law by courts in England has been significant over the years. The concept of tort of law evolved from the common law system which was developed by English courts. So that in the sense, over a period of time, it has started from long period, and nowadays also we are following England law system. So it's like evolved from the common law system and developed by the English courts. So tort law is the branch of law that deals with civil wrongs and liability, which may arise from intentional or negligent actions or omissions that cause harm or loss to another person or their property. So, as I said, it is a civil wrong, and those torts are like negligent actions. Because of negligent action, somebody will get harm. So it may be loss. Somebody may get as a loss. So these are all comes under tort. And how about the history of this torts development by courts in England? So the development of tort law in England can be traced back from 13th century, where the courts recognized the tort of trespass, which involved the unauthorized entry or use of another person's land or property. So, what is trespass? So, simply we can say like enter someone's land or property without permission. Suppose A and B are there. So, A is entering into the B's property or land. So, that will call as a trespass. So, over the years, the courts developed various other torts, including negligence, nuisance, and defamation. So all these has been evolved in England only. So in the 13th century, after 13th century, these has been evolved. So negligence, nuisance, defamation. So what is negligence? What is nuisance? And how they have evolved these things in England court means we will see. So let us discuss about the negligence. Negligence means in the name itself negligence. Because of someone's negligent act, and someone will be suffering. So it's like one of the most significant developments in tort law in England was the recognition of the tort of negligence in the landmark case of Dono versus Stevenson in 1932. So this case was very famous during 1932. So Dono and Stevenson were the neighbors. They were staying as a neighborhood, and Dono versus Stevenson case was became very famous. So this case established the principle that a person owes a duty of care to others. Dono versus Stevenson is a famous case in English law that established the foundation of negligence law and the concept of duty of care. It is also known as the snail in the bottle case. So Dono sued Stevenson for damages after drinking a ginger beer that contained a decomposed snail. The case reached the House of Lords, where the law lords ruled in favor of Dono by a majority of 3 to 2 judges. They applied the neighbor principle, which states that one must take reasonable care to avoid acts or omissions that could harm one's neighbor. So neighbor called for some party, and that neighbor had offered that ginger beer. In that, one dead snail was there. So after drinking that, Dono consumed that snail, and after that he had some severe injury happened. Some health issues were raised. So immediately Dono raised a suit against Stevenson, and court law of the court also favored to the Dono, saying that one must take reasonable care to avoid acts or omissions that could harm one's neighbor. So this is we can call as a neighbor principle also. So we just remember like Dono versus Stevenson in 1932, and this one also calling as a snail in the bottle case. This has become very famous, and this case we can write for negligence, and this has been developed during 1932 itself. So that is the reason nowadays also we are using this case, and nowadays we are following, and still in future also we will follow. And the basic we are considering from Dono versus Stevenson in the case. So this case has the reference, we can say negligence. In our exams and all, we can write this case also, Dono versus Stevenson case. And vicarious liability. So vicarious liability also developed during England time only, and after 13th century only. So the courts also developed the concept of vicarious liability, which holds an employer liable for the tortious acts of their employees, where the acts are committed within the scope of their employment. So if employee does any wrong, so ultimately, employer has to take the responsibility, because employer is the supervision. Under the supervision of employer only, employee is doing. So if anything goes wrong, and employer also should take the responsibility. So employer should take the liability if anything employee has done something wrong. So vicarious liability examples like employer and employee. Just now we discussed, and parent and child. Sometimes whatever child harming to another child or another person, or another property. So that time parent should take as the responsibility, or parent should take come under liability. That is what a parent child example. And doctor and nurse. So nurse was giving some unknown injection to the patient. Due to that injection, patient died. So that means who can take the liability? So doctor also responsible, and nurse also responsible, doctor also responsible. So primarily doctor can take the liability, because under the supervision of doctor only nurse is going to inject to the patients. So because of doctor instructions only, nurse was giving so and so injection. So that is the reason primarily liable for doctor. We can put doctor as the primarily liable. So this is what a vicarious liability. This also improved during the time England courts only. So this one also we can write. And product liability. So some companies were developing some products. Because of that products, people were insured. So then manufacturer companies should take the responsibility. That is called product liability. So this also has been improved in during the England courts only. And for this, some case also reference is available. That one is a Grant versus Australian Knitting Mills in 1936. This case established the principle that manufacturers are liable for harm caused by defective products, regardless of whether they were negligent or not. The courts have continued to develop tort law in England, including the recognition of new torts, such as a tort of invasion of privacy, which was recognized in the case of Douglas versus Harlow Limited in 2001. So where this started in 13th century, and this case reference was brought up in Douglas versus Hallow Limited in 2001. So that is the reason most of the torts laws has been evolved during the period of developments in England courts only. So this one also we can portray like a Douglas versus Hallow case also we can consider as a reference. So overall summary. Overall, the development of tort law by courts in England has been significant in shaping the law of civil wrongs and liability, which has been adopted by many other countries around the world. So this is about the development, torts development by courts in England. I hope you understood. So let me rephrase or let me summarize what we discussed. So the topic is torts development by courts in England. Before discussing about this one, I told that we always learn about what is a tort, what is crime, what is a breach of contract, and what is plaintiff, what is a defendant. After this, we discussed about the history where this torts developed. So in England, so that history we discussed. After that, some torts examples, liabilities like negligence has been evolved, and vicarious liability has been evolved, and product liability has been evolved. And apart from this, some other privacy related also has evolved, and it is continuously evolving. So these are the primary things. Apart from this, other thoughts also has been improved, but these are the major thoughts which were developed from 13th century to till today. So this is about thoughts development by courts in England. Thank you.